You're listening to Sirens, a true crime podcast, brought to you by the Sirens Network. This podcast contains explicit content, so listener discretion is advised. The opinions expressed on this podcast are solely the views of the hosts and do not reflect the views of affiliates, associates, or sponsors of this podcast. This is Sirens, a true crime podcast.
On the far end of the Trail of Tears was a promise. Forced to leave their ancestral lands in Georgia and Alabama, the Creek Nation received assurances that their new lands in the West would be secure forever. In exchange for ceding all of their land east of the Mississippi River, the U.S. government agreed by treaty that the Creek County west of the Mississippi shall be solemnly guaranteed to the Creek Indians. Both parties settled on boundary lines for a new and permanent home to the whole Creek Nation, located in what is now Oklahoma. The government further promised that no state or territory shall ever have a right to pass laws for the government of such Indians, but they shall be allowed to govern themselves. 1832, Treaty Article 14.7, Statute 368. Today, we are asked whether the land these treaties promised remains as Indian reservation for purposes of federal criminal law. Because Congress has not said otherwise, we hold the government to its word. This is an excerpt from McGirt versus Oklahoma. Jimcy McGirt. So in 1997, Jimcy McGirt was tried and convicted of first-degree rape by instrumentation, lewd molestation, and forcible sodomy in the District Court of Wagner County, Oklahoma. McGirt was convicted by a federal jury after evidence was presented proving the defendant sexually assaulted a 4-year-old child. The victim, who is now in her late 20s, testified that the defendant touched and penetrated her, made contact with her vulva with his mouth, and caused her to touch his penis with her hand with the intent to arouse or gratify his sexual desires. McGirt, who was 72 at the time of his trial and who is from Holdenville, Oklahoma, was sentenced to life imprisonment and 5 years supervised release for 2 counts of aggravated sexual abuse in Indian country and 1 count of abuse sexual contact in Indian country in violation of Title 18 United States Code. The life sentences on each count were ordered to run concurrently. While serving 2 500-year sentences and a sentence of life without parole in the Oklahoma Department of Corrections, McGirt, who was a Native American, challenged his conviction, arguing the crimes occurred in the Muskogee Creek Nation Reservation, and Congress had never disestablished the reservation. Therefore, the state of Oklahoma did not have jurisdiction to prosecute him. So on July 9th, 2020, the United States Supreme Court agreed with McGirt and vacated his state convictions. In the McGirt ruling, a 5-4 majority on the U.S. Supreme Court ruled that the Muskogee Nation's reservation was never disestablished, and that a large majority of Oklahoma remains Native American reservation, and that major crimes involving American Indian victims or perpetrators on reservation land cannot be tried by state officials. In August 26, 2021, after his conviction had been vacated, a federal court upholds Jimcy McGirt's conviction. Sean Michael Bosse. Bosse of Blanchard, Oklahoma, was charged with first-degree murder for the killings of 25-year-old Katrina Griffin, a woman he had briefly dated, and her 2 children in 2010 inside a mobile home near Dibble. They died when their mobile home was allegedly set ablaze by Bosse. Katrina Griffin, who was 24 at the time, and Christian Griffin, who was 8, were fatally stabbed. Chastity Hammer, who was 6, died of smoke inhalation after she was locked in a closet by Bosse. Prosecutors said Bosse stole from the woman and killed her and her children to avoid arrest for the thefts. He was found to have pawned more than 100 of the stolen items while the trailer was still burning. June 26, 2011, the police recaptured Bosse after he escaped from a jail near Oklahoma City. 28 years old at the time, Sean Michael Bosse overpowered a guard at about 10 a.m. that Sunday morning and took the guard hostage and then fled in a 2004 Pontiac Grand Prix, which he later abandoned. He was recaptured by police without incident. August 31st, 2021, Bosse's conviction is vacated because of the McGirt finding. October 7th, 2021, the court turned down appeals by Sean Michael Bosse. He had argued that the state had no jurisdiction to prosecute him because of a U.S. Supreme Court ruling in what's known as the McGirt Decision that limits state jurisdiction on tribal lands. Bosse's victims were Native American, and the crimes occurred on tribal lands. But the state court has found that McGirt does not apply retroactively, and that convictions and sentences were final before the McGirt ruling. So what cases have I talked about on this show that has been affected by this McGirt ruling? Meaning, how many murderers have had their convictions vacated because of the McGirt ruling? Well, number one, Rachel Woodall, who was killed by Tyler J. Mullins. Possibly the Oklahoma Girl Scout murders, if Jean Leroy Hart had actually had a conviction in that trial. Brenda Carter, who was killed by Caleb Bourne. Deborah Sue Carter, who was killed by Glenn Gore. Thelma Sauls, who was killed by Jessica Moore. The reason I bring this up in this episode is because when the McGirt ruling happened, a lot of these sentences, a lot of these convictions, a lot of these trials were all put on hold so that they could determine where they needed to go. Like, for instance, if someone was convicted and then their sentence was vacated, that means that they either need to go to tribal court or they need to go to federal court because they can't have been heard in state court. And a lot who are pending trial, they're trying to figure out where they need to go. They need to go to federal or they need to go to tribal court. And so there are a lot of questions that come from this ruling, and a lot of cases that have been affected. A surprising number of cases that I have talked about here on this podcast myself. So in this episode, I thought that it would be beneficial to my listeners if we could get a prosecuting attorney to come and sit down and talk with us. And I have got one of those for you today. So I have Carrie White here with me in the studio, and we're going to get to ask her some questions and maybe clear up our misunderstandings of what McGirt and Bosse are.
I'm Carrie White. I appreciate being here today. I'm an attorney, I'm a judge, and I've been a prosecutor for many years, and I'm glad to be here.
And you're with one of the major tribes here in Oklahoma that this has severely affected, right?
I have worked with them, yes.
Today I'm just going to ask you some questions so that we can kind of figure out what is going on, because no one really seems to know what any of this means. So what led up to the McGirt ruling? Was it just a question of jurisdiction?
It was a question of jurisdiction, and this started with cases before McGirt even. But in the McGirt case, the question was whether the state of Oklahoma had jurisdiction to try Jimcy McGirt. And the reason that was a question is because you actually have to go back many, many years to get the start of this. So when the tribes were removed from their ancestral homes and brought to Oklahoma, the federal government gave them so-called reservations. And for a while, many years, that's where the Native Americans were required to stay, was on their reservations. Then came a time when the federal government decided, no, we're not going to do reservations anymore. What we're going to do is we're going to give allotments. So we're going to give each Native American a piece of land of their own. Instead of having everyone stay on one reservation, we're going to give each individual person 160 acres or whatever it was. When that happened, a lot of people in the government and lawyers and judges and legislatures felt that those previous reservations had been disassembled. And that was probably the intent of the federal government, was to disestablish those reservations and simply allot each person property of their own. However, in many of the treaties that were signed between the federal government and those tribes, there was not specific language saying many terms like disestablishment, or we're revoking your reservation, we're getting rid of your reservation, any of those words that would say the reservation is no more. It wasn't found in those treaties. And that's where that lawyer from McGirt, which very smart lawyer, found those missing words and brought that case. What he said was, these treaties with, at the time I believe it was the Muskogee Creek Nation, this treaty with the Muskogee Creek Nation does not say if we give each person an allotment, you will disestablish your reservation. It doesn't particularly say that, although that may have been the intent. So here we are 100 years later, this lawyer figures this out. He's apparently the only one to do so for 100 years, but it's a very valid argument, and the Supreme Court agrees with him. So what that does to McGirt, to Jimcy McGirt, who was convicted of molesting a 4-year-old girl, what that does is takes jurisdiction away from the state of Oklahoma and gives it to the federal government. And the reason for that is that reservation that was given to the Muskogee Creek people, the Supreme Court said that still exists. It's not just the Muskogee Creek Reservation, it's also Oklahoma. But who has jurisdiction in that little area of Muskogee Creek Nation, Oklahoma? And the Supreme Court found that it was still with the tribe because that reservation was not disestablished, even though it's, and that's why most people are confused. It's still Oklahoma, but it's also now Muskogee Creek Reservation. And although Muskogee Creek, they don't get that property back, what the treaty does say is that they have jurisdiction over crimes in that area.
But it doesn't establish lines like, here's where it would have been, so this is the jurisdiction that it's in.
Yes, each tribe has their own reservation that was given to them back in the early 1900s. They have their own reservation. Creek is up here in Tulsa. Chickasaw is down south. Choctaw is southeast. They all have their own lines. I don't know how many counties are in the Creek Nation. I know the Chickasaw Nation has 13 and a half counties. So those counties are whatever tribe was originally given that reservation area. That's where crimes would be tried now after McGirt. In the Jimcy McGirt case, what happened was Mr. McGirt sexually abused a 4-year-old child. The problem with that case is it was 20 years ago.
Yeah.
And so when McGirt overturned those cases that people thought were in Oklahoma, but now they're in Muskogee Creek, what happened was all of those people, convictions got vacated. And so instead of just releasing those people out of the jail, what the courts will do, and when I say the cases are vacated or their convictions are vacated, that means it's gone. It's like it never happened. There will be no record of it. The courts dismiss the case. They dismiss everything, and they would wipe it from any record. Now, instead of just letting Mr. McGirt out of jail once it was found that the state of Oklahoma didn't have jurisdiction, what happens is when the court says, yes, we agree with Mr. McGirt, we don't have jurisdiction, state of Oklahoma does not have jurisdiction, we're going to release Mr. McGirt, but we're not going to do so for 60 days. That gives the federal government or even the tribal government time to file a case against Mr. McGirt and start their process. And so with it being 20 years ago, there's a lot of evidence that the federal government had to recollect that's 20 years old. And thankfully, the young lady that was actually abused remembered everything and was willing to testify again. But that McGirt case is not the only case that's been affected by this ruling. There are hundreds and hundreds of cases in Oklahoma that this has affected. And there have been hundreds of people let out of jail because their conviction, their Oklahoma State conviction, was vacated. Some of those cases the federal government did pick up. Some of those cases the tribes picked up. And the way that they determine who picks up those cases is, if it's a major crime, arson, murder, rape, assault, major crimes like that usually go to the federal government. The more minor cases will go to the tribes themselves, and you'll go to tribal court.
Like burglary and stuff like
burglary, drug crimes, drunk driving, public inchancing, those kinds of things.
But some of those weren't picked back up.
Some of them were not, because there was such chaos in the courts that prosecutors had to go through hundreds and hundreds of cases to see do we want to prosecute this again? Maybe the person had already been in jail for 10 years. And if the person had already been in jail for 10 years, maybe they didn't want to prosecute again.
So they did consider time served when they were going back over this stuff.
Yeah, many prosecutors did. And so, and depending on the crime itself and the time served, lots of factors that prosecutors had to go through to figure out if the case and the evidence. Do you have evidence from 20 years ago or whenever the case was? Lots of things that prosecutors had to go through to decide whether they wanted to pick this case up again. And I know the federal government has very limited resources. They could not pick up every case. There's no way they could pick up every case. And so for a while, it was just murders. It was the most heinous crimes that they were picking up, and they were letting the tribes pick up some of those other cases, which does not mean the federal government can't later go and charge those. They just weren't doing it right away because there were so many of them. They had to pick the worst ones to get those people off the street and not to let them out of jail.
And weren't you telling me the other day that they had picked up one of them, like the tribe had picked up a major crime, even though they'd been sending him pretty much all to the federal government?
Yeah, and the tribes will pick up some of the major crimes because tribes can still prosecute any kind of crime that they have in their code. So let's say the Creek Nation has, they have a crime for murder. They have a crime for rape. They have, it's in their code. It's in their criminal code. They can still charge those things. Right now, the sentencing is very limited. Tribes can only charge felonies 3 years.
So that's why they send them to federal.
Right.
To get life or death.
Exactly. And sometimes what happens is those cases that, let's say rape, for instance, the tribe will pick up just to get that guy, off the street, in jail, hold him in jail, and give the federal government an opportunity to review the case more and file charges if they want to. So there's kind of a dual jurisdiction. If it's in the criminal code for the tribe, they can also charge. They can pick up any of those cases.
I talked about Bosse earlier. He was like the very first one after McGirt that said, this also applies to me. It just happened to be murder and not molestation. But is it because it was a major crime that he thought it also applied to him?
Yeah, there's a federal law. It's called the Major Crimes Act, and it says the federal government can prosecute any Native American on a reservation or Indian country for certain crimes. And as I said before, that would be murder, attempted murder, rape, arson, the really heinous ones.
Do they have to, does the federal, I mean, it's the federal government, but do they have to have the permission of the tribe first to prosecute that? Like, does it go to the tribe first and then the tribe says, no, we want to send that to federal, see if they want to pick it up?
You know, there is some conferencing that goes on between the federal prosecutors and the tribal prosecutors. They will get together and say, you know, here's a case I need to talk to you about where when it needs to be prosecuted. We don't want to, you know, leave this guy on the street. Is this something you guys think you're going to be able to pick up? And when do you think you're going to be able to pick it up? And so there's a conferencing that goes on between the federal government and the tribal government about what cases will go where.
Okay.
So, I mean, it's not, nobody needs permission from the other. If both of them wanted to file charges, they could.
So they could technically have a trial going on in tribal court and federal court at the same time?
You could, but I don't know why you would want to, because, like I said, the tribe is only going to be able to give that person 3 years.
Yeah.
And if he's going to get, 20 years in a federal facility, then there's really no reason you would want to do that. You'd be wasting resources.
And with any other jurisdictional thing, just like the different counties, they kind of, like when you have somebody, like with the R.J. Thompson case that we're going to talk about, they have different counties, and they discuss with each other, like, well, who's more likely to get the guy.
Right, and the prosecutors, the city prosecutors or the county prosecutors, when you have a crime that's in several different jurisdictions, they'll kind of get together and have a conference and say, look, most of the evidence is here in my county. Will you guys willingly give us, your evidence and let us try everything in one county? Because it's more likely to get a conviction in the county that has the most evidence and has the jurisdiction as well to try the person. So there could be more than one jurisdiction, but the prosecutors kind of get together and decide what's the best alternative for that.
And the problem that we had here with McGirt was that he was saying, well, they didn't have jurisdiction to try me in the first place. So then that's what started this whole thing.
Exactly.
They found, the Oklahoma Supreme Court found that McGirt is not retroactive. What does that mean?
When the McGirt decision came down from the Supreme Court, everybody assumed that meant all like cases. So that means, any case that has to do with tribal jurisdiction, that's going to apply to all of these cases. And the Supreme Court, when it made that McGirt decision, didn't say from today on.
Right.
It didn't really give a timeline at all. So everyone is assuming that means
everything
all
forever.
All cases forever since Oklahoma
became a state.
Wow. And so there was no, it was just kind of left blank. They didn't say it was, they didn't say it wasn't. Now, the Oklahoma Court of Criminal Appeals addressed that specifically, and what they said was it is not retroactive. And what that means is it does not apply to all these cases in the past, these 20-year-old cases, these 10-year-old cases. It only applies to cases going forward. And the reason that they thought about that, and there was a lot of factors. Oklahoma, for one, said, this is just causing too much chaos in our court system. The federal government, they can't handle all these cases. But what the Court of Criminal Appeals, what they fell back on was, this decision was a procedural decision. And what they mean by that is just the process of how cases are brought to court. Who files the case? Who tries the case? After the conviction, where does the person, reside, go to jail? Go to prison. Which prison does he go to? So it's process. It's a procedural question. Lots of people are arguing it's not procedural, it's jurisdictional. So that makes it not retroactive. If it's a procedural question about how you do something, how something is done, what is the procedure, it does not apply to all those old cases. Now, that's what the Oklahoma Court of Appeal said. However, the United States Supreme Court has not ruled on that yet. So as of today, McGirt is not retroactive. But nobody's following that rule because they're waiting on the Supreme Court. Because if the Supreme Court says, yeah, it really is retroactive, then you're having people that are, you're stopping and going and stopping and going, and so everybody's just waiting for the Supreme Court.
So I talked about some of the cases that I've talked about here on the podcast, like Rachel Woodall and Brenda Carter, Deborah Sue Carter, that was a big one, Thelma Sauls, a lot of these just from Ada alone. But when this first came out, there was a big question of what's going to happen because their sentence is vacated. Are they just going to let him out, just let him go, let him walk free? And they actually held them and gave, like you said, the federal court time to pick some of those up. Most of them have picked up. But when they say, oh, wait, it's not retroactive, does that mean, oops, we vacated, but now we're saying that it's not vacated? How do you unvacate something?
Yeah, and that's why the Court of Criminal Appeals decision, no one is really going by that yet, because there has been, all of these cases have been vacated. And if it's not retroactive, then oops, we shouldn't have vacated those. Everybody's kind of waiting. And that's the best thing to do, because the Supreme Court has the final say. If the Supreme Court says that it is not retroactive, then those convictions will be reinstated. And will they go and look for a bunch of these people that they've let out of jail? Maybe, and maybe they won't, because I think that they're going to have the same process thought in their brain about, is it worth going to look for these people and putting them back in jail when they've already served 10 years, when they've already served this?
Well, I mean, like Debbie Carter, Glenn Gore's been in jail since the early 90s? I forget, but a long time. But then again, you have some people saying, well, but it's still murder, and if they got a life sentence, they should serve a life sentence.
Right, and I think that's part of what will be considered is the actual crime. If it's burglary, you stole a $2,000 trailer and you got 10 years and you served 8 of it, are they going to go back and, if they're going to unvacate you, or, are they going to go after you? Probably not. But most of those murders and those more extreme crimes, the feds have already picked up. So those people are still in jail anyway. It's just going to be a process of when are they going to take them from federal court back to state court?
Right.
When are they going to take them from federal prison back to the state prison?
Now, the tribe doesn't have... do they have a jail? Do they have a prison?
No, I don't think any of the tribes have their own jails. If they do, I'm not aware of them. So what they have to do is they have to contract with the county jails. Uh-huh. Let's say Oklahoma City Jail or Tulsa County Jail, or and they pay them by the day to hold their prisoners.
Whoa.
And so they don't have any prison contracts that I'm aware of. So right now people are just being held in the county jails.
Well, that would be interesting. If they got their own prison in the future, that would be interesting.
Yeah, I mean, a lot of the federal prisons, some of them had closed down. President Biden had closed some of the federal facilities.
I didn't know that.
And so there's actually a empty federal prison in Oklahoma that would be perfect for the 5 tribes to adopt.
Yeah.
Get together and say, let's contract out this prison that's sitting empty.
Yeah. I guess what we're all wondering, this is something that I've heard people ask over and over again. I got a couple of messages to the page that asked this. Everyone wants to know, what requirements have to be met in order for it to fall under the McGirt ruling? Is it just the perpetrator has to be a tribal citizen, or is it the land, or is it the victim has to be native? Is it all three, or is it just one?
It depends on the crime. Okay, so if it's a major crime, and if you are a Native American person in any of those reservations, any of those 5 tribe reservations, in their jurisdiction, it has to be within those reservation boundaries. Either you have to be Native or your victim has to be Native. One or the other. If you are Native and commit the crime, then you go to federal court. If you are not Native and you commit the crime, you go to federal court. Now, if you're not Native and your victim is not Native, that's state of Oklahoma.
But it is, like, if you're not Native and your victim is not Native, but it occurred on tribal, quote, tribal land.
Doesn't matter. Well, as I said earlier, it's still Oklahoma. Okay, so you've got the tribal jurisdictions that you just kind of set down on Oklahoma. It's kind of like a little map, and you just color in the tribal lines, you color in the reservations, lines. But it's still all Oklahoma. So if you are not Native and your victim is not Native, the state of Oklahoma has jurisdiction over you.
Have you seen anyone yet who is not Native and their victim is not Native, but then they've seen this McGirt case come out and said, oh, I need to establish that I am Native?
Sure. A lot of people in prison are rushing to get their tribal affiliations that they'd never had before. And that was one of the things. I think there was, might have been a couple of cases, and it might be in some of these Supreme Court petitions that are ongoing now that say, look, there should be a cutoff as to when you can say,
right,
I'm Native. If
right.
you didn't, if you didn't bring that up at the beginning of the case, you shouldn't be able to bring it up later. Now, if you committed a crime 20 years ago and you said you identified yourself as a Native American, then, and you had a CDIB card or a tribal enrollment card, then 20 years ago, then, the McGirt finding is probably going to apply to you. But if you identified as non-Native, white, black, Asian, something else, and you had not gotten your CDIB card yet, you did not get your tribal enrollment yet, you just did so recently, then that is probably, I'm not going to say that McGirt is not going to apply to you, but what I am going to say is that might be some of those cases that the Supreme Court looks at and says, look, you didn't establish, that you were Native American 20 years ago. It's not going to happen now. So that's another question that's going to be up to the Supreme Court.
It's a lot of questions.
Yeah, and you said at the beginning, you said, it's this super confusing. Everybody wants to know what's going on. Mm-hmm. Nobody knows what's going on. Everybody has a different take on all of this. All we can do is wait for the Supreme Court to, make a decision and please tell us what do we do? Where do we go? So,
well, yeah, and it's the victims' families, victims of like murder and stuff like that. I mean, there's like this huge outcry because to their knowledge, those murderers are being let out back on the streets. Well, that's not exactly what's happening, but they still feel like, well, now, we got justice and now we're not getting justice. Justice is being taken from us. And there's this outcry, but it's always towards the prosecutors, and the prosecutors are sitting there going, we don't know either.
Right, exactly. We have no idea what we're doing. Nobody knows what they're doing.
I mean, this is unprecedented.
It absolutely is. And it's that was one of the arguments in the McGirt case, or it might have been in the Murphy case, which came before McGirt. But, the Supreme Court said, state of Oklahoma, we understand your argument. We've been doing this for 100 years. You've had jurisdiction for 100 years. But just because you've been doing something wrong for 100 years does not make it right. And so everybody is just, so upset that, the criminals are getting away with things, and Some of them may. Some of them may be getting out of jail. But the ones that have committed the really bad stuff, they're not getting out of jail. They're still in jail. They're being prosecuted either by the tribe or the federal government. And, hopefully soon we'll have an answer that just clarifies everything on this issue.
Well, see, and that's the something you mentioned earlier. What I was wondering, the government, just initially, the government gave these tribes these reservations. But then later they were like, oh, no, never mind. We're going to do plots of land. How can they just take land back that they have already given?
Well, and that's a really good question, and that's one of the things that Native Americans are super upset about.
I can imagine,
because it is the federal government just doing whatever they choose to do. They thought moving the Native Americans from their ancestral lands to Oklahoma was the best thing they could do. They would put them all in this, one area. Homesteaders could come and have the other land. Well, and then people just kept coming west and coming farther into the United States. And, then the federal government said, well, this isn't really working out for us. So, what else can we do? Well, we'll give the Indians their own land. And of course they had to
per person instead of the whole
per
tribe.
person. And so then they can do whatever they want to. If they want to sell it to the homesteaders that are coming in, let them sell it to the homesteaders.
Well, and that's a thing that we talked about at the beginning of this season on Holly's Hauntings. We talked about Pitcher, Oklahoma, and the fact that like in the early 1900s, the Quapaw tribe was given all of that. And then they figured out that there was a mine to be had and was like, oh, we were just kidding. Would you like to rent it out to us or whatever? And when they were like, no, we're doing fine on our own, they were like, okay, well, we're just going to take it back.
And that's, that's scary because, we're talking about Native Americans who were really not part of the government back then. And so it's just really scary what the government can do, and there's nothing you can do about it. And it could be you and it could be me. Anytime, the government could decide to do something, pass a law, and there's not a lot that anybody can do about it. So, vote in those legislators that you believe in and that are going to do good for the citizens.
Yeah, a lot of people say it's not worth it to vote, but it is.
It really is.
Yeah. Well, I think we've answered all the questions, at least that I have. I'm sure I'll have you on in the future for other episodes to maybe explain some things here and there. So if anyone out there has any questions that they'd like answered, you can always email us or go to the website, thesirenspodcast.com, send us your questions, and we'll try to get them answered for you. But thank you so much for being with us today. And we're also going to have you on the RJ Thompson episode, and we're going to have you explaining some stuff there as well. So we really appreciate having you.
Okay, thanks. Thanks for having me.
You've reached the end of our episode. All suspects are innocent until proven guilty in a court of law. Join Raven next time on the Sirens Podcast.
Do we have an outro? That's our outro, isn't it?